case number 204526501. The people of the state of Michigan versus Kenneth Jones. Defendant is charged with one count of communication. Sir, what are you doing with your camera? What's going on? Is the vehicle stationary? You can't be in a moving vehicle. Okay, well, can you stabilize your device, please? Defendant is charged with one count of communication services illegal use. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Kenneth Jones. Mr. Jones, sir, please unmute and tell the judge your full name.
My name is Kenneth Alvin Jeremiah Jones Sr.
Today is the date set. Whoops. For pretrial conference, Ms. Stevenson.
Your Honor, we believe the complainant's presence was required today. If there is no complainant present, we will move the matter be dismissed.
Ms. Ritter.
Judge, it's a precedent of the pretrial conference. The court did require the complainant witness present in the arraignment. I don't see the complainant witness connect Elise Parker in the waiting room, Judge. I don't believe there's any unidentified devices in the breakout room. At this time, the people would not be able to proceed based on the complainant witness's failure to appear.
Oh, Ms. Shive is in with the jail. I required the complaining witness to appear on the communication services illegal use.
Yes, sir.
Why? Who is the complaining witness?
I believe it's civilian complainant witness.
How would they prove that it was illegal use of a communication services device? Communication services device sounds like the police have to prove that. I don't understand. What do the complaints say? What does the complaint? Did you all hear me say what do? Oh my goodness. What does the complaint say? In terms of, can you just read the complaint to me so I can conceptualize how that could be a civilian witness?
Yes, Judge, I'm pulling the complaint up right now.
Your Honor, may I say something?
No, you may
Not
not.
yet, Mr. Jones, please. Thank you, sir.
You may not.
So the complaint reads, did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, harass, threaten, molest, annoy, or disturb peace and quiet of Jeanette and Elise Parker by threatening physical harm or damage to any person or property in the course of a conversation or message through use of a telecommunications service or device.
So
I believe.
Okay, so okay.
So I believe, Your Honor, the complainant witness will be necessary to establish the elements that Mr. Jones used some type of telecommunication device to make threats or harassment.
Wouldn't that what? Okay. Ms. Stevenson might be saying, Judge, you're acting like the prosecutor. I'm not.
No, I'm not saying
Okay.
that.
So what is she? What will prevent the people from subpoenaing the records from in a text message from the service provider, and the service provider coming in and saying this message is from this phone that belongs to this person and went to this phone that belongs to this person? You're saying that's, and I'm not thinking the proof's all the way through. I'm asking.
I'm just wondering how, if that were the mechanism of proof, how that would establish a threat or a feeling of harassment.
If he sent a text message that said, I'm gonna slit your throat if you don't blah blah blah, that's a threat.
If that is the way it's perceived, that is subjective. Set to a reasonable person's standard.
She could come in there and say she wasn't scared, and then the jury could say a reasonable person would be scared. So
I believe that the jury instruction is that the complaining witness actually has to feel threatened.
I don't know, because that means that means nobody could ever commit a crime against me, because I'm not scared of nobody. But if they say I'm gonna come in there and shoot you in the head, and I say I wasn't scared of him because I had a gun too, that means they can't be charged with threatening me. Yes, they can.
Yeah, I would.
Reasonable person. If a reasonable person would feel threatened or I don't know what it says because I ain't looking at it right now.
The reassonable person and the complainant, Your Honor.
No, because the complainant could be unreasonable. I don't know. You're saying that if a complainant says that they felt threatened, but a reasonable person wouldn't feel threatened, then it could go against them. But
no, I'm not saying that. I'm saying that if the whatever it is, the complainant has to feel threatened.
Right, but what if the complainant feels threatened?
And nobody else would feel threatened? I don't think that matters.
Yes, it does. Why do they put a reasonable person in there then, Ms. Stevenson? Why would the reasonable person be in there? But why am I the one that's going to asking Ms. Stevenson these questions? Why am I? Okay, Ms. Ritter. So are you saying you don't believe the people can, you don't believe, I did kind of sound like a prosecutor right there, Ms. Stevenson. You don't want to acknowledge. Ms. Ritter, you don't believe that you can meet that, whatever the proofs that you have to prove beyond a reasonable doubt, you don't think you can meet them without the person to whom the threat was made?
Judge, the people are saying that.
I'm not sure what's going on with the person in the courtroom, though. I mean, the person in the courtroom, what are you doing, sir? You're in court and you leaning your head back and you.
My neck hurt. Oh, you're talking about in court, right?
Oh, that's for sure.
He said he's under the weather, Your Honor.
Miss Ritter? No, you can't keep talking, sir. Miss Ritter.
So, Judge, what the people are saying is that the court requires the complainant witness to be here, and the complainant witness is not present.
Now, why would Mr. Jones put his whole ear up to the camera?
Because I can't hear y'all.
So then that means you need to get some headphones or something, sir.
I mean, I had to get out the car and walk in the gas station and buy some.
You just heard me say what I just said.
Yeah, I heard y'all, but it's like your phone, it's like the volume just went real low on the phone for some reason. 1 minute it was sounding clear as day, and next minute everything just went low.
Because you in a car coming to court?
Huh?
So, Mr. Jones, please just sit still, sir. Thank you.
All right. I'm gonna reserve, so the complaining witness has failed to appear. And the court the court arraigned the matter, and so I'm gonna look at the jury instruction because I think Ms. Stevenson is reading the assault and battery jury instruction. When you say that that it has to be that the person felt threatened, because that would seem to denote that if an individual used the communication services device to threaten a school, to send a bomb threat, and then the school said we weren't worried about that bomb threat because we knew they couldn't even, bomb us up, then the person can't get convicted. And I don't agree with that. And so I don't know if I specifically said the complaining witness should appear, or we're just going by the fact that I arraigned it, and therefore that's generally what should occur. But I need to see the jury instruction, or I need to see the MCL.
Your Honor, 750.540E, malicious use of service provided by telecommunications service provider. A person is guilty of a misdemeanor who maliciously uses any service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, or annoy a person, or to disturb the peace of the quiet of another person by any of the following, and then it drops down.
Right, and the intent is on that person. So the intent says if the person uses the communication service device and their intent is to threaten, terrorize, harass, blah, 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 blah. Now, does it also then say, and the people have to prove that the person who received the message from the telecommunication actually felt threatened, terrorized, intimidated, harassed? And that's where I'm saying it's not necessary. The complaining witness is not necessarily necessary.
Okay.
And I don't know if I actually said the complaining witness had to come, or if we are going by what my customary thing is. But at this point, I'm not willing.
So, and our motion is going to be dismissed, Your Honor, based upon our February 22nd arraignment wherein the court did require, according to my notes, that the complaining witness be present today.
It was a mistake. The motion is denied. The motion is denied unless when the people, if the people go back, notwithstanding like the complaining witnesses of failure to appear or not coming, if the people go back and say, well, no, we actually cannot. No, nobody spoke to Miss Terry. Why she come out?
Can I ask a question?
To your lawyer in a private breakout room.
I want to ask
Could we?
judge.
Oh, no, sir. I understood your question when you asked it. And my answer to you is that you may ask a question to your lawyer in a private breakout room. Questions to me are not, no, you cannot ask me a question. You can ask a question to your lawyer in a private breakout room. And if it is appropriate for my record, then she will let me know. Would you like to speak with your lawyer?
Yeah, I'd like to speak to my lawyer.
Well, I need you to make sure you continue to watch your tone and your demeanor towards me. That's what I need you to do. Continue to watch your tone and your demeanor towards me. I'm going to attempt to send Mr. Jones back to a breakout room so that he can have a private conversation with his lawyer and ask whatever questions he wants to ask to his lawyer in an appropriate fashion. He was in breakout room number 3. I'm going to send him to breakout room number 11.
We appreciate that. Thank you, Your Honor.
You're welcome. Miss Terry, I don't know why you came out of that breakout room when I said 5 times, remain in the breakout room until somebody comes in to speak with you. So I don't know why you came out of the breakout room, but you're going to have to wait now in the waiting room until I can send you back to the breakout room. I'm ready on, oh, you didn't speak to Mr. Boggs though.
Ms. Shive did, and I think we're ready.
All right, I'm ready on Boggs. I don't have any information, so can somebody read? Can someone read his case number?
Case number 2204569801, the state of Michigan versus Antonio Boggs.
What is he charged with, please?
Charged with count 1, assault or assault and battery. The only count.
All right. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Antonio Boggs. Mr. Boggs, sir, please tell the judge your full name.
Antonio James Boggs.
Mr. Boggs is charged with violating the tether. And part of the reason why the defendants probably should remain silent is because when they say stuff, it will be used against them in the court of law. Mr. Boggs admitted that he violated the tether by going to the location. Ms. Stevenson?
So, Your Honor, on April 5th, the court did dismiss a previous tether violation, ordered that the tether remain, that it did take off the house arrest. Mr. Boggs is aware that the court narrowed his exclusion zone, that he just couldn't be within 500 feet of the complaining witness's house, and he couldn't be in the company of the complainant. But as everybody heard Mr. Boggs state,
here's that video from earlier.
Mr. Flanagan, you have a tether violation for Mr. Boggs?
No, Your Honor.
These tether violations go back to the person who put them on the tether.
I don't have anything from today. We actually handled him on April 4th.
So did I keep him on a tether?
Let me look it up to see.
you did, Judge.
Well, today is only April 11th. Why he got out and got back on violation?
That she was in a car accident. So they called it, I was supposed to be around her. She was in a car accident. They tried to jump her. So she called me. And I went over there and they called her violation.
I know you staying in jail then. Okay, I'm sorry. Let's go to the breakout. Go send them to the breakout room. That don't even, that's not even making sense that's not even making sense. That's okay. Miss Stevenson, I'm gonna send the jail to the breakout room.
Okay.
Thank you. Okay. All right.
He did believe that there were some exigent circumstances, Your Honor, which caused him to, after he was called by the complaining witness into her company to give her some assistance, he responded at the risk of his own freedom that he should not have done that, Your Honor, but he did not come into contact with Ms. Sanders for the purpose of harming her in any way. In fact, it was only for the exact opposite that he violated this court's order. And he did that at the invitation and really at the request for assistance of that complainant.
Yeah, so, she probably set him up. She said they let him out on that tether. I watched it, and they told him not to be bothered with me. And now I'm going to call him and tell him to come help me, and he's going to come, and they're going to come and get him. Oh, that's just me in my head saying, why would you fall for that? Now, whether or not that's true or not, that means any. So when I gave my order, I didn't say, at no time did I say, unless she has an emergency and she needs you to come help her. I never said it. Never did I say that. I never said that. I never said it. And I lifted the house arrest restriction, allowed Mr. Boggs to go free about the world, and I gave him 2 conditions. Don't go within 500 feet of her house, and don't go near her. And he couldn't abide by that.
I didn't go near her. She was in the police car. I did not go anywhere near her. I went to the accident scene, to the car accident. I never went near her. She was inside the police car.
I don't know why he's over talking me. I don't know why he's over talking me. I don't know why Mr. Boggs is over talking me. Because he thought that I didn't know that from when he said it the first time. So here's where we are. The court is going to sustain the tether violation. Mr. Boggs is in violation of the tether. His bond conditions that were previously set are revoked. Mr. Boggs' bond is going to remain where it is. What was the bond?
So the bond was $2,500 personal plus the GPS tether with a pretrial conference set in 338 on May 9th, Your Honor.
The bond is now $2,500 cash surety plus a GPS tether with house arrest. If he bonds out before he sees Judge Garrett, then that's fine. If he does not, then he'll be there when he sees Judge Garrett.
Your Honor, would the court consider I hear the $2,500, but would the court consider a 10% of that with the GPS tether, at least if there's some money on top of it that might serve as an additional
that's not even needed, man.
Tug for Mr. Boggs, Your Honor. And again, we would just reiterate.
What he's not going to do, so let me say this, he's getting ready to be remanded. So since Mr. Boggs is so disrespectful, and he left, he's remanded until May 9th.
Okay, can I finish my record though? Your record though? My argument.
Finish my record.
My argument on your record, Judge. I meant to say that, but we're asking the court to consider $2,500, 10% with the GPS tether, and reminding the court, as I'm sure it's aware, that the complaining witness, according to the information I have, has not appeared on this case, Your Honor, which we started, I think, as early as January. She was not here on January 5th, not here on February 15th. And certainly not ordered to be here anytime after the 15th. But she hasn't been here, Judge. And I just bring that to the court's attention. I don't believe.
No, so now he's probably in jail unnecessarily.
That is my argument exactly, Your Honor. Looking to the likelihood of successful prosecution of this matter, I would ask the court to consider $2,500, 10% with the GPS tether, Your Honor.
It's $2,500 cash surety with a GPS tether.
Thank you, Your Honor.
You're welcome. I assume, are you ready on Culpepper? Because I brought him in. Well, he not ready, sir. That's. I mean, I promise you, when I die and not like if I linger and I'm gonna be laying there and I'm gonna be saying, I probably could be living longer if I would have saved some of the breath I used to repeat my instructions 10 and 12 times in court, and then the people still don't follow the instructions. Ms. Shive, are you ready on Culpepper?
I am, Your Honor.
Who was laying back in the car, even though I said you must remain seated in an upright position, ready to attend court at all times. This is case number 22. Five 845-201, the people of the state of Michigan versus Wilbert William Culpepper. The defendant is charged with 1 count. Oh, that's that same thing. Okay. One count of illegal use of a communication services device. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina O'Brien on behalf of the people.
Jessica Schreiber on behalf of Mr. Culpepper. Mr. Culpepper, please state your full name for the record.
Wilbert Will Culpepper.
Today is the date set for a pretrial conference. I know it's at 8:36, which might mean that I said the complaining witness had to appear, but Ms. Ritter, what are the circumstances? What is if it's the same as that other case, I'm going back on what I said.
I'm sorry, Your Honor, can you hear me better?
Yes.
So, Your Honor, according to the investigator's report, there was a dispute between the complaining witness and the mechanic regarding some mechanical services to the victim's vehicle.
And then, but where do the communication services device come in? Like, was it text messages or phone conversations or what?
So there were text messages, Judge, where the defendant. I'm sorry, Judge, I'm reading over the investigator's report.
That's fine.
So there were sexual harassment claims or allegations between the mechanic and the victim on Facebook and text messages.
So, Ms. Schaub, I know you weren't the lawyer. The person that I just led into the courtroom, you have to be in a stationary vehicle. You have to be in a vehicle that is not moving.
Okay.
Miss, ma'am, it's not a conversation. I'm directing you that you're not going to be able to attend court in a moving vehicle. Miss Shive, I know you were not present when we discussed that case, the one that Mr. Jones, but it is the court's position that the people, if these are text messages that was sent to an individual, then the court's position is that the people may be able to proceed without the person who actually received the text messages, because they could subpoena those records from the provider. And so while it is at 8:36, the court is going to deny the motion to dismiss. I don't even know if I let you make it today yet.
You didn't, but Your Honor, respectfully, we would have moved to dismiss given that the complaining witness is not here. But if the court is not inclined to dismiss, then we respectfully ask the not guilty plea to be continued and set for a final pretrial in hopes of resolving this matter.
So, and this is my position with respect to that. So the motion can be renewed after the discovery is received, and if the people believe that they do need that person, like that the person is not necessarily the complaining witness, but a necessary witness for them to meet their burden. So we can make that decision, or they can let me know at the final pretrial conference if that person, even though they could. So if Ms. Ritter, the way we're looking at these cases then is if you subpoena the records and the keeper of the record comes in and testifies, will that be sufficient to meet, what you have to do? All right. So the court is going to continue the matter to a final pretrial conference. I will set a final pretrial conference for Tuesday, July 11th, continuing a not guilty plea on behalf of Ms. Culpepper. Discovery should be submitted to the defense by June the 12th. And then Byron will continue with no contact with the complaining witness. Anything further?
Nothing further. Was it 9 a.m.? I'm sorry, I missed the 9.
Oh, I didn't say it. Thank you. At 9 a.m. 9 a.m. All right. Okay, then we're all set until July 11th. Ms. Culpepper, have a great day. Stay safe.
All right.
All right, you ready on Martin?
Yes.
She don't play.
Oh, wait, I'm sorry. Let me just double check.
As you see, she don't play, y'all.
Sit down.
Yes, I'm ready on Martin.
This is case number
I worry.
214431201. The people of the state of Michigan versus Anthony Martin. The defendant is charged with one count of malicious destruction of property. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina O'Brien on behalf of the people.
Jessica Schreiber on behalf of Mr. Martin. Mr. Martin, please unmute and state your full name for the record.
Yes, hi. My name is Anthony Leroy Martin Jr.
Today is the day set for pretrial conference. How are we proceeding?
Your Honor, respectfully ask the court to set this matter for a final pretrial, Your Honor, and continue a not guilty plea.
Oh, he almost hit the baby.
Mr. Martin. Mr. Martin, the baby don't know. They don't know that you in court. It's okay. You'll be all right. That's all right. Ms. Ritter.
She loves babies. Judge Bryant loves babies.
Oh, did she? No.
Your Honor, I would have respectfully moved to dismiss. However, I believe the complaining witness here is the Detroit Detention Center, so I'm not sure if the court is requiring.
Oh, I wasn't aware. Okay. Ms. Ritter, like, Judge, you weren't paying attention. That was her way of saying that. Because I was focused on the baby. So you're right.
She loved babies. Told you.
Is the complaining witness the Detroit Detention Center?
That is correct.
Okay. So then, all right.
No, I don't take the.
It's the DDC required. All right, then the court is going to continue a not guilty plea on behalf of Mr. Martin. Set the matter for a final pretrial conference, July 11th at 9:00 a.m. Discovery should be submitted by June the 12th. Bond will continue, and then I can't say no contact with the complaining witness because but hopefully he will have no contact with the DDC. Hopefully he will have no contact.
Can you imagine? You guys can't take me.
I'm not going to order it in. If they try to arrest him, he'd be like, you can't. Because the judge said I can't have no contact with the DDC. All right.
That's right.
Mr. Martin, you're all set. Have a great day and stay safe. Thank you. All right.
I will say, I love this judge, and she loves babies. I told you. I will say, I love this judge. And I love the prosecutor, too. And that looks like an amazing defense attorney. And she loves babies. You see that? Not a hint of any kind of snap in her voice about that baby. She loves her some babies. I love babies, too. Give me a like if you love babies. Give me a like if you don't love babies, because I need some likes.
Ms. Stevenson, I had to do that because
Okay.
you was taking a long time, and I'm not. That's not a negative thing. I shouldn't say you were taking a long time. I need Ms. Jones to. Okay. I needed to bring Ms. Terry back in because she was. So I needed to bring her in, and I had to close them down. So now I'm going to send everyone. Oh, I didn't mean to bring Mr. Hendricks in. He has a plus sign. So now I'm going to send everyone back to the breakout room. Then I'm going to transition down to the courtroom.
Okay.
I'll take a couple of people, but I'm going to have to fit them in between my jury now because I know.
Okay.
I have some preliminary stuff to take care of with respect to the jury trial.
Okay. I think we're on. We're in good shape right now.
Okay. All right. So everyone that I just brought in, I'm going to send you back. If you were already there, I'm going to send you back. And if you weren't there, I'm going to send you to a breakout room. Do not come out. Listen to me, ladies and gentlemen. Do not. And I need you to have a seat, Ms. Jones, and stay in your seat. Stay in your seat and be ready. Listen, I have a jury trial. You can get caught up and have to wait for the whole witness to finish testifying if you want to. When I bring you out of the waiting room, I need you to be ready. I'm not going to wait on you. I'm not going to wait on you. I have a jury that is waiting to come into the courtroom. You need to be ready. Do not come out of the breakout room until you speak with a lawyer. Do not. Do not. Do not. All right. Please accept to join the breakout room. I need Miss Lee Armstrong to turn on your camera. I'm afraid. Hold on. Let me close that. Then she went without turning on her camera. Okay, so now I gotta wait. Miss Lee Armstrong, you need to turn on your camera. I'm sorry. I'm trying to work this app. I don't know why y'all do that. All right. There's nothing to do on the app except click. When I say turn on your camera, you click and turn on the camera. And please take that bonnet off your head, ma'am. You are, and I hope you don't have on pajamas. Ma'am, I'm sorry. Ma'am, I really don't. I'm not even concerned about whatever your personal situation is. We're in court. We are in court. And then either you're going to be in court or you're going to talk to the person next to you.
Should I head back in, Judge?
Yes, unless you want to handle Hendricks right quick.
I'd like to do Hendricks, Your Honor. That'll take a little bit longer. Yes, please.
Ma'am, you didn't join the breakout room.
I don't see the option to join the breakout room.
You weren't paying attention to your screen. You was talking to the person next to you.
Honestly, Your Honor, I'm not even supposed to be here today. You told me I didn't have to go to court after today.
Okay.
But you didn't put it on the documents, and that's the only reason why I'm woke, because they just gave me
Ma'am.
Yes?
If I told you that you didn't have to come, and you paid the money that I asked you to pay, then don't come. But what you're not going to do is come and be in your pajamas and be rude and disrespectful. So if I said you didn't have to come, then you should not have come. But don't come and then get held in contempt when you come because you're coming inappropriately.
Okay.
Miss Stevenson, I don't have time for this. So she didn't go to the breakout room. I don't know if she was supposed to come or not. I'm ready on Hendricks. You can figure that out and let me know.
Okay.
Case number